Darkcast Network, indie pods with a dark side. Hello and welcome back to Fuck That. Today is part 3 of Chad Hauer, aka the TikTok Fugitive. I'm really excited because this is going to be my last episode on him solo. There's going to be a part 4 at some point where it's just going to be kind of a candid discussion between Chad and I about his experiences during this entire ordeal, as well as other incidences that may or may not be related. This is going to be more just kind of a theoretical conversation on experiences that he had that are unrelated to the case, but that might tie into things. And additionally, I chatted with Chad today. It's Sunday, the 7th. You're going to be hearing this tomorrow, so yesterday. And I'm going to be releasing a series of videos via audio of his recounting of his experiences in Bulgarian prison. So I think that that'll be really interesting for you all to hear as well, completely from his perspective. So just want to recap part 2. Again, if you haven't listened to part 1 and part 2, you have to. You're going to be completely lost. I mean, I guess you could, YOLO, but you're not going to know what's going on. In part 2, I talked about how there was a bench warrant issued. The FBI ended up indicting him on federal kidnapping charges. He was apprehended several months later in Bulgaria after actively traveling across various countries during his conference schedule, where he was kept there for 3 months. Bulgaria dropped the charges because they're like, there's nothing fucking here. And he ended up returning to St. Kitts. Chad returned to St. Kitts on New Year's Eve in 2009. So by March of 2010, Chad's lawyer filed for an appeal with the Superior Court of Pennsylvania. This appeal requested that they vacate the orders issued by the trial court and to find that the Commonwealth of Pennsylvania never had and still does not have jurisdiction to adjudicate issues of custody in relation to Alex. And in this appeal, there were 2 questions posed. The first, did Pennsylvania legally assume jurisdiction over custody matters related to Alex, or is there another forum that properly has jurisdiction? And in this appeal, they argued that the answer is no. And are the orders appealed from appealable? They argued yes. Obviously, everything I discussed in part 1 as well as part 2, which in truth barely scratches the surface, all of this was laid out in the appeal, focusing on the issue of jurisdiction, as Alex was born in Tennessee and had barely lived with Nance. And again, when he did move to Pennsylvania, this was done without authorization or notification. Even when Pennsylvania claimed emergency jurisdiction, Tennessee courts still had the case. But remember that even though the judge took emergency jurisdiction in Pennsylvania, he still ordered Nance to return Alex to his father, specifically citing that she must abide by the Tennessee court ruling. So just very confusing. None of it's clear. The response from the Pennsylvania Superior Court, which was filed on April 19th, particularly the section that addresses jurisdiction, it's very long, so work with me as I read the statement regarding jurisdiction. Quote, the Pennsylvania Superior Court does not have jurisdiction in this matter, as the orders appealed from are interlocutory and are not final. So this whole response was drafted by a child advocate in Pennsylvania Supreme Court. And this woman throughout this entire reply has a lot of audacity, let me tell you. Regarding the 2 arguments raised in Chad's appeal that I just mentioned, did Pennsylvania legally assume jurisdiction over custody matters related to the child? They insist, yes. Quote, after applying the requirements of the Uniform Child Custody Jurisdiction Act in effect at the time of the review, the court appropriately assumed jurisdiction. So what did I do? I spent a couple hours reading about Pennsylvania Title 23, Chapter 54, the Uniform Child Custody Jurisdiction and Enforcement Act, UCCJE. This was actually enacted in late 2004, so not that much prior to when this was all going on. But I'm now going to read Subchapter B, which is jurisdiction, Section 5424 regarding temporary emergency jurisdiction. And I'm going to start with A, which is the general rule. Quote, a court of this Commonwealth has temporary emergency jurisdiction if the child is present in this Commonwealth and the child has been abandoned, or it is necessary in an emergency to protect the child because the child or a sibling or a parent of the child is subjected to or threatened with mistreatment or abuse. So hang on to those two things, abandonment and abuse. I'm going to skip over B because this is regarding a situation where there is no previous custody determination or proceeding, but C specifies previous custody determination or proceedings. And it says, quote, if there is a previous child custody determination that is entitled to be enforced under this chapter, or a child custody proceeding has been commenced in a court of a state having jurisdiction under sections 5421 through 5423, any order issued by a court of this Commonwealth under this section must specify in the order a period that the court considers adequate to allow the person seeking an order to obtain an order from the state having jurisdiction under section 5421 through 5423. The order issued in this Commonwealth remains in effect until an order is obtained from the other state within the period specified or the period expires. This is really important. I'm going to circle back. I got into the order from Pennsylvania in part 2. I'm going to circle back to it right after this, but none of this was done, right? So Pennsylvania can take emergency jurisdiction if there's a reason to. There's no abandonment or abuse, which we'll get into, but let's say hypothetically there is abuse in this instance. The Commonwealth of Pennsylvania can take emergency jurisdiction, but they must reach out to Tennessee and they must obtain an order from that state because that state has jurisdiction. And this order will only remain in effect until there is an order obtained from Tennessee or the period expires. So there also needs to be a time limit placed on this emergency jurisdiction order. D implicitly states that there needs to be mandatory communication between the courts. Quote, a court of this Commonwealth which has been asked to make a child custody determination under this section, upon being informed that a child custody proceeding has been commenced in, or a child custody determination has been made by a court of a state having jurisdiction under the same sections, blah, 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 shall immediately communicate with the court. A court of this Commonwealth which is exercising jurisdiction pursuant through the same thing, upon being informed that a child's custody proceeding has been commenced in, or a child's custody determination has been made by a court of another state under a statute similar to this section, shall immediately communicate with the court of that state to resolve the emergency, protect the safety of the parties and the child, and determine a period for the duration of the temporary order. Now that I've laid out the requirements to use emergency jurisdiction, I would like you to ask yourself if, according to Pennsylvania's very own statutes, did the Venango County judge truly have the authority to do so based on this? I don't think so, because again, according to Pennsylvania, a child must be abandoned or abused, neither of which are true in Alex's case. Additionally, nobody, including the Commonwealth of Pennsylvania, contacted Tennessee courts and bothered to try to solve it with Tennessee courts. On top of that, this is meant to be an interlocutory, temporary order. It's supposed to have a timeline attached to it, and this expires when they are either hearing from the Tennessee courts and they get an order from them, or the parameters in terms of timeline expires. There's no timeline on the judge's orders. So I want to circle back to something that I discussed in part 1, and that is Nance's original petition that this emergency jurisdiction was based on, as well as some other documents from 2006, because I want to compare them to UCCJE, which is essentially the basis of Pennsylvania's rebuttal to Chad's appeal. Now, again, in 2006, this is when Nancy filed her petition with Pennsylvania. If you remember, she did this while she had summer visitation with Alex. And instead of putting him back on the plane, she strategically waited until the end of August, right when she was supposed to send Alex back to Chad, to file this petition, and then refused to send him back. I'm going to read verbatim from specific points that were brought up in this petition to solidify Nance's bullshit case. And the first is, quote, "The father removed the child from the United States of America and relocated him to the country of Turkey until around April 7, when they moved to the country of Cyprus, where he remained until your petitioner secured physical custody of Alex on June 10th, 2006. The child is scheduled to be returned to the father's custody and presumably the country of Cyprus, parentheses, though the father has indicated they might be moving to Bahrain this fall, end parentheses, on or about the 15th day of September 2006. The child has expressed to his mother that he does not wish to return to the primary care and custody of his father, and your petitioner does not believe it is in the child's best interest to return to the father for several reasons, which include, but are not limited to, the following. When in primary custody of his father in 2005 to 2006, the father was typically not available to care for his child. The child is not receiving an appropriate education. The child's communication with the petitioner has always been sporadic when he is with the father. Cyprus and the nearby country of Lebanon and surrounds are not a safe place for the child, and neither is Bahrain. The child was residing and or staying in an apartment in the country of Turkey and the surrounding area, was involved in a riot that necessitated the government to bring in 500 or so riot policemen, tear gas, a tank, and riot dispersal equipment, and further damage was done to the apartment complex. And the last point is the family's vehicle was broken into several times and the father was apparently mugged. This is all going to loop back to UCCJE, which is the premise of the state's rebuttal to Chad's 2010 appeal. So just hang tight, I promise. But I want to dissect the complaints in this petition to demonstrate that there was absolutely zero evidence of abandonment or abuse, which is what the parameters are in UCCJA, according to the Commonwealth of Pennsylvania. I'm going to start with Nance's claim that Alex expressed to her that he does not wish to return to his father's custody full-time and that he was not around to care for Alex while Alex was with him. Now, obviously, I was not present when this allegedly happened. There are only two people that know if this is true, Nance and Alex, but I want to play a somewhat recent audio clip of one of the interviews that Alex himself has done regarding his father's case.
In the beginning, pretty much my mom had full custody. The guy's living with her, and my dad had visitation custody, and she would not send me to him for visitation, and they kept having to get to court to force her to give me to my dad for visitation. And then at one point, she moved to a completely different state. So she moved a couple hundred miles away without telling my dad or telling the court that she was moving, which is completely illegal. So after that happened, they gave my dad full custody. And that's pretty much how all of this started.
Now, this is just my assumption, but I think that if Chad was in fact an unfit parent, and if Alex truly wanted to live with his mother at that time, Alex's interviews would sound very different today. Now, regarding Alex not receiving appropriate education, Chad informed me that Alex was enrolled in private school while he stayed with him. In fact, he stressed that each institution that he went to was a known and respected institution globally. I did some research on one of the private schools Alex attended, which is Logos School of English Education in Cyprus, and Chad was telling the truth. I'm going to link their website in the show notes, but the institution was established in 1973, and it does have a very good reputation. Nancy also implied that Alex was in danger in Turkey because of a riot that involved a tank, among 500 officers in riot gear, and several other things. But I found no such record. In fact, I found 2 different protests in Turkey that year. There could be another. I scoured the internet for a decent amount of time, and I could only find these 2. But the first was in March, And this involved around 300 people peacefully chanting for women's equality. They were dispersed with tear gas, but there was no damage to property. Nobody was injured. That was the end of it. The second was in September, and again, it wasn't a riot. It was a protest. Nationalists ended up throwing eggs and tomatoes at participants of a conference on Armenian genocide. I'm going to link the article in the sources, but there's absolutely no mention of rioting. There's not even a mention of police. Now, the last complaint states that the family's car was broken into several times and that Chad was mugged. Chad has always and has continued to state that he was never mugged, but yes, the car was broken into one time. He also said this happened to him when he was younger and lived in Pennsylvania. This has personally happened to me a few times. This isn't something that's unique to Turkey or Cyprus, and I feel like to suggest that this exclusively happens in those two countries is kind of fucked up and distasteful. And since we want to talk about other countries and how dangerous they are, let's talk about Pennsylvania being such a beacon of light and how much safer it is than Cyprus and Turkey. Have any of you ever heard of or walked around Kensington? I would take my chances in Turkey and Cyprus any day of the week over a lot of places in Pennsylvania. So, as a refresher, Nance's petition for custody was filed in Venango County on August 10, 2006, but it wasn't until the 30th that the judge ended up taking the emergency jurisdiction. But remember, he implicitly stated that regardless of the emergency jurisdiction, that Nance must abide by the Tennessee order and send Alex back to Chad. Again, totally contradictory. Now I want to talk about the Pennsylvania court opinion that was issued in September of 2006 that kind of solidifies and backs the emergency jurisdiction order. But basically, in my opinion, all of it directly contradicts UCCJE. The court insisted by lying as well as omitting very important information that Alex's true domicile was Pennsylvania and not Tennessee. But again, keep in mind, Alex was born in Tennessee in 1996 and did not leave until mid-2004 when Nance illegally removed him from the state without notifying the court in Knox County or Chad. Because Alex had lived in Venango County with Nancy illegally as of September 2004, and because Chad and Nance were both born in Pennsylvania, even though they left the state around 94-95, and because both Chad and Nancy had some family in Pennsylvania, it only makes sense that they can take jurisdiction, right? According to them. Referring back to UCCJE really quickly, I want to read directly from some definitions. They define home state as, quote, the state in which a child lived with a parent or a person acting as a parent for at least 6 consecutive months immediately before the commencement of a child custody proceeding. I'm going to read directly from the Pennsylvania opinion, and hang on because it's basically an entire paragraph of bullshit. Quote, the Tennessee court addresses that in its findings, and the child was physically present in Pennsylvania after September. First of all, the grammatical errors that you heard were not me. I'm reading directly from this fucking document, so bear with me. And it's a legal document, mind you. And that in his findings, and the child was physically present in Pennsylvania after September of 2004 for periods vastly in excess of 6 months. Jesus fucking Christ, man. Haven't you ever heard of Microsoft Word editing? The Tennessee court was not inclined to treat the child's time as 6 months because during part of that period, the mother was in defiance of the Tennessee order. This isn't a quote. I'm just breaking off for a bit. Should that not be considered true? How can domicile, 6 months domicile, how can you take time when the mother is in defiance of a legal court order? How can that be counted as time? I digress. Part of that time was probably attributable to this court because this court dealt with the matter and attempted to communicate with the Tennessee court, but did not do so promptly and took longer to resolve the matter in Pennsylvania than we should have. All right, so they're admitting fault and still shoving their fingers up their ass and doing nothing. This is the part that really just fucking ticks me off. I am so pissed. Notwithstanding the Tennessee court's finding, the child had been with the mother in Pennsylvania from September 13, 2004, principally until the Tennessee judge awarded custody to the father in October of 2005. The child was again in Pennsylvania from June of 2006 to the end of August 2006. Since September of 2004, the child has been in Tennessee at best a few days. I'm going to fucking rip this apart, so just fucking bear with me because I'm a little bit, I need to start meditating. Let's start at the beginning. September of 2004, this is when he was able to find out where Alex was because of that phone call where Alex muttered, "We're moving to Cherry." And then Nance hung up the phone like a fucking bitch. But, so you go from September to December. In December of 2004, not even 3 months, Chad was granted temporary custody of Alex. This was one of the instances I mentioned in part 1 where Alex had to be removed by Venango County Sheriff's Department, the very county that has started all of this nonsense, from Nancy's home because she was refusing to abide by court orders. She's been in contempt of court in both Pennsylvania and Tennessee, so Alex is removed. Now, do you really think a mother that gives a true fuck about her kid is going to do something that has him removed by a sheriff's department? No, but I digress. So that's less than 3 months, right? If you remember, Chad was living overseas with his wife, but they moved to Tennessee. They rerouted their whole life to live with Alex in Tennessee, and Alex was enrolled in school in December in Tennessee until March of 2005. Again, Nance is granted custody. Again, they're trying to give her grace for whatever fucking reason because she has been a fucking nightmare this entire time, but whatever. But she is required to send Alex overseas in June. So Alex was in Pennsylvania for some time again in March. But June, this is when Chad's parents arrive at Nance's to pick up Alex. I had talked about this again in part 1, but she was MIA. Oh, this is so inappropriate on so many levels, but classic Nance. So when she refused to comply again, custody was given to Chad in Knox County on August 17th, 2005, effective immediately. Couple of things. Pennsylvania states Chad was given custody 2 months later than he was. Gonna reread it. The child has been with the mother in Pennsylvania from September 13, 2004, principally until blah, 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 blah. The judge awarded custody to the father in October of 2005. Nope. Knox County, August 17, 2005, effective immediately. Why did they state that it was 2 months later than when it actually was? And also, how can the court try to use the months where Nancy illegally brought Alex to Pennsylvania, for starters, and when she illegally withheld Alex from his father? How can they use this as months of residency? To me, this is absolutely astounding. I'm fucking irritated. I know I say this a lot, but this is so blatant and in your face. I am astonished that this was even allowed to happen and has not been ridiculed by people other than outside parties. I mean, how has somebody in Pennsylvania, how has federally this not been torn up since the FBI is involved? At the end of the day, Alex has spent less time in Pennsylvania than he has anywhere else. Cyprus, Turkey. I mean, he has spent less time in this state than literally any other fucking place. And this is the premise of their argument to establish residency without abandonment and without abuse. And also, there's no fucking residency. So the reason why I kind of wanted to circle back to all of this is because I want to now present the two issues raised in the appeal once again, starting with the first. Did Pennsylvania legally assume jurisdiction over custody matters related to the child, or is there another forum that properly has jurisdiction? I wholeheartedly don't think so. Nor does Chad, nor does Alex. And this is the subject of this entire dispute. Second, are the orders appealed from appealable? Again, Chad thinks so, but Pennsylvania argued no. And here's the fucking kicker. The orders are not final because they were interlocutory. That is the reason why they said that it is not appealable. Don't hate me, but I'm going to circle back to the UCCJE again and again. This is because this is the premise of their argument, and it really just disproves everything they have to say. So, quickly quoting this section again, the order issued in the Commonwealth remains in effect until an order is obtained from the other state within the period specified or the period expires. But remember, this section implicitly states that there needs to be a time frame and that Pennsylvania must contact Tennessee to settle the dispute, or it would expire based on the time frame. But Pennsylvania did not contact Tennessee. Chad did. But because Chad was not in any violation in Tennessee, they couldn't do anything. So because Pennsylvania failed to notify Tennessee, he was stuck in limbo because in Tennessee's eyes, Chad was abiding by the custodial agreement. Now, Chad ends up getting stuck in this limbo from August 30th, 2006 until May 21st, 2021. So not only did Pennsylvania fail to adhere to the following, and I'm going to paraphrase because I already read this, a court of this Commonwealth, which has been asked to make a child custody determination, skipping ahead, shall immediately communicate with the other court, skipping ahead again, upon being informed that a child custody proceeding has been commenced, shall immediately communicate with the court of that state to resolve the emergency, protect the safety of the parties and the child, and determine a period for the duration of the temporary order. But the order was clearly not temporary. It was upheld for 15 years. I would argue then that perhaps Pennsylvania arguing that this is not appealable because it is interlocutory is bullshit. What concerned me the most about all of this is that there is absolutely zero guidance regarding time in interlocutory orders. I couldn't find anything on the state level nor the federal level. So I guess I just don't get why a judge wouldn't use an interlocutory order for fucking everything using that logic. When these are appealed, they are continuously shot down because they're temporary. There is absolutely no framework, no recommendations, no guidance on what the timeline should be on these, quote, temporary orders. By that logic, why not always issue this kind of order just to cover your own fucking ass from an appeal? That's how I see it. Chad's attorney filed a brief reply on April 25th, and the Superior Court of Pennsylvania filed their response on July 21st, 2010. Unsurprisingly, their response was a word salad. Quote, because father's appeal is merely another request to have the trial court reconsider its prior orders affirming jurisdiction over the instant custody matter, we quash the appeal as untimely. There is a discussion, and it reads, quote, on appeal, father argues that pursuant to UCCJE, which has been adopted in Pennsylvania, blah, 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 Pennsylvania is not and has never been the home state of child. In addition, father argues that the trial court has refused to enter a final order, preventing father from filing an appeal to this court on the issue of jurisdiction while he suffers the consequences. After a review of the parties' briefs, relevant case law, and the certified record on the appeal, we find that father is doing nothing more than once again challenging the trial court's jurisdiction over the parties' custody dispute, jurisdiction which the court assumed in its September 6, 2006 order. Wrong. That order was issued in August. What they're referring to is the opinion. So they can't even get this right. Anyway, back to quoting this. Although it appears that father did appeal from that order, that appeal was quashed for failure to comply. We are also confounded. That's a great word. We use that a lot in public health, confounded. We are also confounded by the fact that father voluntarily decided to not attend multiple scheduled custody hearings throughout 2006, where he clearly could have contested the court's jurisdiction and custody rulings. Instead, father has chosen to repeatedly refuse to recognize and honor that the trial court's custody orders and still, as of this date, has failed to return the child to the U.S., where he has been ordered to reside with mother. Accordingly, because the trial court's latest order included nothing new in substance, but simply reaffirmed its prior orders, continuing to retain exclusive jurisdiction over the parties' custody dispute, and reiterated that mother had been granted sole physical and legal custody of child. We find the appeal untimely and appeal quashed. There's so many things to say. First of all, the way that they just keep saying father, mother, not the father, the mother, father, mother, like it's just super, I don't know. It just makes me really uncomfortable. But there's a lot of things wrong with this, most of which we've already covered. But the reason why, and I covered this in part 1, Chad did not send Alex in 2007 was because what the fuck happened when he sent him in 2006? Nancy withheld him. She had to be ordered by Pennsylvania, who took emergency jurisdiction because he was in danger. They took emergency jurisdiction because he was in danger, and yet the judge still ordered Nance to abide by Tennessee ruling and put him on a plane. And then, remember, she literally dropped off the face of the fucking earth. Letters were sent back. Chad reached out to lawyers saying, hey, Alex and I can't get in contact with Nancy. So I asked this in part 1, and I'll ask again, would you, under those circumstances, send your fucking kid again the following summer? Fuck no. No parent that truly cared about the safety of their child and loved their child would do that. And I think that that's exactly why Chad didn't do it. He loves Alex. He doesn't want anything to happen to Alex. And Nancy has proven time and time again that she will keep him just to spite Chad, not to benefit Alex. And this is what's problematic about her. It's not for the betterment of Alex's life. It's simply to spite Chad. I'm going to skip to 2011 when Nance was ordered to appear before a judge. I fucking love this. She was ordered to appear before a judge in Knox County. I wish I would pay so much money to be a fly on the wall when she received this fucking order. So in August of 2011, and this is regarding, because keep in mind, even though Pennsylvania is swinging their dick around, Tennessee courts still fucking have jurisdiction. So this is regarding her lack of child support payments. I know I've said this a lot. I can't get over it, but Tennessee still fucking has jurisdiction and Pennsylvania is living in La La Land. I don't know. This is probably like a weird Commonwealth thing. I don't fucking know. Once Nance caught wind of this, she was having none of that. And in true Nance fashion, this is how she responds. She sends a fucking handwritten letter on notebook paper to the judge. I shit you not. It is literally a handwritten letter on notebook paper. And not shockingly, the judge replies and obviously says, Nance, I can't fucking read this. I'll submit it to the attorneys. I'll put it in your file, but I literally cannot read this shit. If it's not brought up in court, I cannot. I have to remain neutral. Everybody knows this. You can only take in what happens at the hearing. I don't know what she was thinking. So the hearing came in August. Nance obviously failed to appear. I think she was probably out frolicking through some Pennsylvania fields with some wild horses. But she was ordered to pay $20,208.88, which includes what she owed back in the previous episode that I mentioned. But now this is through July 31st, 2011. Do you guys think that she paid it? No? All right, cool. She doesn't. So in 2012, Nance obviously never responds or pays, and she loves being in contempt of court. She is held in civil contempt on February 3rd, 2012. The Tennessee courts ended up garnishing her wages. They placed a lien on her Social Security, workers' comp, and any settlements or lawsuits that she may have. I'm not going to lie, I love everything about this. I wholeheartedly support this. Garnish everything. Garnish her fucking toilet paper, garnish her fucking utensils. Ugh, I love it. Now I'm going to jump to 2016. In 2016, this is like I swear to God, this is like a dick measuring contest. And I can't between the two courts. It's unreal. Pennsylvania has so much audacity, but Venango County ordered Chad to pay $1,876.82 for child attorney fees related to the case and was ordered to appear in court on April 29, 2016. And they're threatening him with another bench warrant should he not appear. This is so fucking childish. I feel like at this point, they are truly just trying to kick him while he's down. Why does he have to pay these child attorney fees? This should fucking be on the court in Pennsylvania, which clearly doesn't know how to do their job. Or, matter of fact, put it on fucking horseback rider. Chad obviously didn't show up because he's a fucking gangster, and this is a waste of his time. Honestly, why would he take off from work, fly halfway across the world? It's just ridiculous. And they never ordered a bench warrant because they're literally just trying to shake him up. And it's just, this isn't how the law should work, in my opinion. The law is not meant to intimidate innocent people. It's meant to protect innocent people, but here we are. So I'm going to jump way ahead to 2019 and 2020. But before I get to a 2020 motion filed on Chad's behalf, I want to circle back to the National Center for Missing and Exploited Children, which I touched upon back in part 2. They listed him missing, even though he wasn't. But in 2019, Alex was now 23, and he was still listed on the NCMEC, this is their abbreviation, website, as missing. According to NCMEC's website, in 2003, there was a provision of the Protect Act known as Suzanne's Law. So anybody that was over the age of 18 was considered an adult prior to this provision and therefore was not listed as missing with NCMEC. Now, this provision allowed NCMEC resources to assist in cases involving missing young adults. So now 18, 19, and 20. But again, Alex was 23 and still on the NCMEC website. But what's funny about this is, even though he was missing, his passport was renewed by the U.S. Embassy as a missing adult in 2019.
And NCMEC knowingly listed my son as missing until he was 26. And court orders, they said only a court order can get him removed. They're like, even though we know where he is, and they wouldn't say on the website, they wouldn't say they knew where he was. On the website, they said they didn't know where he was. But, and we have letters from their legal counsel saying we will not remove the child without a court order. But he did news interviews on ABC and Fox. They wouldn't remove him. He was 26. And the entire time he was missing, not only did his mother visit him here, but she wrote him a couple times. In 2011, she stopped writing him. So she had his address, didn't bother to write him. And the U.S. Embassy renewed his adult passport in 2019. He had to meet with U.S. Embassy in Barbados twice. So he's a missing child, but the U.S. Embassy met with him twice and renewed his passport.
On September 21st, 2021, a motion was filed on Chad's behalf requesting a video hearing to purge the bench warrant and ultimately close the case in Venango County, Pennsylvania. Everything that was mentioned in this motion I have already covered in detail across parts 1 through 3, so I'm not going to reiterate that. But one important thing that was brought up is that Nancy now lived in Erie County, and it was believed that she had not lived in Venango County since 2007. On November 18th, Chad was informed that the court denied his request, but they gave no reason. That's very mature of them. On December 29th, 2020, Chad's attorney filed a petition for rule to show cause. Now, on January 4th, 2021, a rule was issued upon the respondent, aka Nance, and she was asked to show why Chad was not entitled to the relief that he requested. She was ordered to file an answer to the petition within 20 days of service, and an argument was scheduled for February 17th, 2021, in Venango County Court. What I love about this, and I'm being sarcastic, is that Chad, even though in his motion requested a video hearing due to his health issues and COVID, they were requiring him to appear in person in February. They rejected this, but then now they have a rule to show cause, but they're like, hey, we know you want to do this on video, but fuck it, we're going to make you come in. So this is just wild to me. Nance replies to this since she now lives in another county. And again, she sends in several handwritten letters to the court and judge. She does not learn her lessons easily, this one. I'm going to just read some of the letter, but one of them is 19 pages, so I'm going to skim. Again, I want to emphasize that this is handwritten on lined paper. And I'm not saying this to poke fun at Nancy, genuinely. I'm saying this because I think it's important to illustrate where she's at. And I think that sadly, you have to look at a parent's mental health and mental fitness when it involves matters of child custody. You need to make sure that whatever parent is going to be considered the custodian of a child, that they are mentally competent. And even though at this point Alex is an adult, that is still the precipice of this argument and has been for 15 years. So her letter says, I, Nancy Oberlander, received the enclosed petition. NWLS doesn't handle this sort of case, and I have no money, so cannot obtain legal counsel. I believe the term is indigent. My only recourse is to send a letter to the court in response. Based on the mountains of files that I've seen from 2003 to now, Nancy's a smart woman. She's a competent woman. She was a self-sufficient woman. This just feels to me that she's really just doing whatever she can to gain the sympathy of the court. I'm just going to get into the meat and potatoes of her rebuttal. In response to Mr. Hauer's petition enclosed, I feel the past proceedings here and in the Superior Court of PA already, quote, show cause, end quote, to not dismiss Mr. Hauer's contempt as well as address his jurisdiction objection. This honorable court did on 2006, December 27, give Mr. Hauer clear direction on how to purge himself of contempt enclosed, and he refused. Also, he appealed the jurisdiction to the Superior Court of PA already and lost, which they even include in their Exhibit 9, and which states the appeal was filed from an order sustaining jurisdiction. She goes on to say that the findings were gone through at various times regarding jurisdiction and that everything supports that Pennsylvania has rightful jurisdiction. She then goes on to list a bunch of exhibits. Regardless of disparaging, my character has on page 5 of the body enclosed clear recognition by the Tennessee Chancellor that other courts could assume jurisdiction, that Pennsylvania certainly is the more convenient forum. This didn't happen. And that it was up to the other court, Pennsylvania, to make the decision. That is true, as I mentioned earlier when we were talking about UCCJE, which Venango County PA Court of Common Pleas did. Then she starts getting real catty. It is convenient of them that this petition neglects to mention how Mr. Hauer refused to follow even the Tennessee custody order they had, keeping Alex hidden overseas after 2006, not allowing any contact. This didn't happen, as I mentioned in part 1, and Chad has provided me with several pieces of documentation, which are also on his websites, solidifying the fact that it was Nancy that dropped off the face of the earth. Anyway, refusing to return Alex to the United States, resulting in Mr. Hauer also being charged with kidnapping, which is still outstanding as Mr. Hauer has brought citizenship in St. Kitts and they won't extradite him. Mind you, this citizenship was already established prior to all of this, so it's a moot point. She goes on to address several entries in the petition, but they don't actually have any fluid thought and they don't actually have any true rebuttal, so I'm going to omit them just because they don't say anything of substance. She then goes on to say for several pages a lot of defamatory things about Chad, which I want to note. I've read almost every correspondence, every court transcript. I've never seen Chad do that. I'm not saying this from a biased perspective. I'm just saying that every single correspondence I've read to Chad, to the courts, to whomever on Nancy's end has been nothing but disparaging and rude. And on the opposite side of that, Chad has been nothing but professional and accommodating. So whenever Alex and I had contact before, Mr. Hauer would grill Alex, upsetting and searing him. Apparently, that had not changed. Again, these are accusations that if they were true, that interview with Alex, I think, would have gone very differently. She then goes on to surmise that he has taken him to several different countries without letting her know, But as I stated in part 1, he always let her know via email. He, in fact, established a international Skype number just so that he could communicate and Alex could communicate with her and keep in contact so that she felt safe with Alex being in another country. Then she goes on to state, quote, if Mr. Hauer wishes to come to the U.S., he needs to face what he did and make reparations. That word. Ugh. Instead, he is trying every which way he can to circumvent consequences while creating hardship for me. Nance, I think it's the other way around, but I digress. I feel these repeated filings years after the fact are frivolous and harassing, and that additional sanctions should be imposed on him. As if he hasn't been fucked over enough. I sincerely thank this honorable court. Oh, I'm doing a fucking jerk off motion in case you guys can't see it, but that's what I'm doing. Jerking off into the fucking air. Any person, regardless of this situation, right? Any person that has spent years of their life with somebody, has had a child with somebody. I know divorces can be contentious, right? But there was something there at one point, right? They had some form of relationship. There should be always a baseline level of respect at the end of the day. You may not like the person anymore. Heck, you could hate them, but there should always still be that, hey, we had a kid together, whatever. Chad has been fucked over for 15 years, and she thinks that it's not enough, and she wants additional sanctions imposed on him. That says to me all I need to know about her character. Oh, man, I'm so fucking pissed off. That letter, man. Anyway, because Nance really didn't address anything, are you surprised? In the motion that Chad filed, in Chad's reply to Nancy's handwritten letter, they requested that what she stated in paragraphs 3, 4, 5, 15, 17, 23, and 24 be considered to be true because she was non-responsive, which was true. I just didn't want to read it verbatim and put you all through that because I wanted to gouge my eyes out with a melon baller reading it, so I'm not going to do it to you, but it was just regurgitation of what we already know to be true. So on May 21st, 2021, Pennsylvania dismissed the custody order as, quote, the underlying issue of custody would no longer be viable, you fucking think, as the child has now reached the age of majority and this court cannot order any custodial time with either parent. Wow. He's fucking 26, do you think? This is what makes me really mad, though. I mean, I'm grateful for that, but like, what the fuck? They still upheld the issue of contempt as, quote, the defendant fled the jurisdiction of this court and fled the jurisdiction of the United States of America and has never made himself available to this court in hearing to resolve this issue. Again, I want to emphasize for the 10,000th time that Chad didn't flee the country. He was already living outside of the United States. And that is where the Pennsylvania judge who took emergency jurisdiction sent Alex in 2006. Additionally, he never refused to attend hearings. He sent legal counsel and immediately informed the courts of specific dates that he was unable to take off and fly halfway across the world to attend a hearing in a county that did not have jurisdiction over his son's case. In March of 2022, Chad filed a motion to tackle the federal charges. Within this motion, Chad's medical issues were addressed. Chad has non-alcoholic fatty liver disease, cholelithiasis, which is just gallstones, and hydronephrosis. And this occurs when there's a buildup of urine in the kidneys, but this causes them to stretch and can very much lead to permanent kidney damage when left untreated. Additionally, Chad passes several kidney stones daily. I mean, he posts pictures of them. This guy, men out there, I don't know if any of you have ever passed a fucking kidney stone, or if you guys watch Friends when Joey passed a kidney stone. The pain that he is going through in that show is literally accurate. It is so painful. And Chad is passing several of them daily that are larger than normal. But Chad cannot travel due to the Interpol Red Notice, and he cannot receive adequate medical care in St. Kitts because the resources are limited. So therefore, in this motion, he essentially made 3 different requests. which I think are above and beyond what he needs to do. Chad was willing to travel to the United States to stand trial, but requested that he be transported there via air ambulance. The motion explicitly stated that Chad would be willing to submit to an extradition process, provided he gets medical care, and he requested that he goes to trial immediately upon arrival to the United States. So he just wanted to be provided with a trial date that was pretty close to when he arrived there. Chad also requested that he would be able to stay with family in Ohio during the trial process, and he stated that he would be willing to wear an ankle monitor. Now, if the government was unwilling to do so, his last request would be that they dismiss the indictment. This is fucking crazy to me, obviously, because Chad, in my opinion, right off the bat deserves to have the indictment dismissed. This man should not be at the point where he is trying to bargain an extradition. He knows that the United States knows that they have no case. They know. But Chad is so tired of living in constant pain that he's willing to agree to extradition as long as they don't let him die and they give him a trial date that is reasonably close. And I am not okay with this. Like, I am absolutely not okay with this, and none of you should be either. This next part, I'm going to try to get through without putting in my opinion at all, because I don't want to be like blacklisted by the United States because, you know, I live here and I love it. But in May of 2022, Assistant U.S. Attorney Christian Trebold issued a response to Chad's motion. It's really like, I think the word I'm looking for is to the point. So A, the court has no authority to order St. Kitts to extradite Howard to the United States. Quote, the court has no authority to order a sovereign nation such as St. Kitts to extradite Howard to the United States, since Howard is apparently, I love that, apparently, he's been there for fucking 13 years, but okay, currently residing in St. Kitts. Any decision on his extradition to the United States is entirely up to authorities in St. Kitts. Howard has cited no authority for the proposition that this court can order his extradition from a foreign country. There is a simple reason for that. No such authority exists because Howard's requests run counter to the basic principles of extradition. Just as a foreign court has no authority to order the extradition of an individual from the United States, this court cannot order St. Kitts to extradite Howard to the United States. I'm going to pause. He wasn't asking for that. He was asking for an air ambulance to the United States. Next, rather than seek an order from the court, Howard can simply voluntarily return to the United States anytime he wishes. Rather than willingly return, Howard has instead fought and evaded extradition since his indictment. Apparently, now that he deems it is in his best interest to return to the United States 13 years after his indictment, he wants the court to order his extradition, but only under certain conditions. Since the court has no ability to grant his request, it should be denied. I'm going to pause again from quoting, but I think that if the same court can order somebody from Barbados to go to St. Kitts, meet up with somebody in local law enforcement in St. Kitts, and try to fucking kidnap his son, I think that they can make stuff happen. I'm just saying, if you guys can make fucking kidnapping happen, I feel like there's really nothing is out of the realm of possibility. Just saying. Anyway, Howard claims that he is confident he will be acquitted, as am I. His claimed confidence is undermined by his 13-year refusal to submit to the court's jurisdiction. Why would someone apparently so confident he will be vindicated wait so long to obtain his supposedly certain acquittal? Well, I'm going to answer that question. Because Pennsylvania dismissed the case, and he didn't think he stood a chance until then. So now that Pennsylvania fucking dismissed the case, he thinks he has a fucking chance. Jesus fucking Christ, man. Do you fucking know how shit works? B, Howard's medical conditions are not life-threatening. I'm not even going to go through this because this man didn't even bother to consult a clinician in any capacity. Not even a fucking registered nurse, a physician, nothing. He looked up one article on Mayo Clinic regarding one of his conditions, hydronephrosis. That's it. So really, he does not have the authority to state whether or not they are. And Chad provided in his documentation 2 different written documents from 2 different doctors that suggest otherwise. C. Hauer is not entitled to a dismissal of his indictment. In the alternative, while a fugitive refusing to submit to this court's jurisdiction, Hauer seeks dismissal of his indictment if his demands are not met. I put this in bold. He has not even tried to identify a basis for the dismissal of his indictment. Guys. Guys. All right. Glazing over that, the federal rules of criminal procedure provide that a party may file a pretrial motion raising any defense, objection, or request that the court can determine without a trial on the merits. He's just citing things. Thus, it is well settled that a pretrial motion to dismiss an indictment is not a permissible vehicle for addressing the sufficiency of government's evidence. That's a scary fucking sentence. A pretrial motion to dismiss an indictment is not allowed when addressing whether or not the government's evidence is or is not sufficient. That's a scary fucking sentence, but it is the reality we live in. He's citing more stuff here. When evaluating a pretrial motion to dismiss, a district court must accept as true the factual allegations set forth in the indictment. Evidentiary questions such as credibility determinations and the weighing of proof should not be determined at this stage. These are all things that should be determined before somebody is dragged through the fucking mud and their life is ruined, but I digress. Rather, the government is entitled to marshal and present its evidence at trial and have its sufficiency tested by a motion for acquittal pursuant to blah, 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 blah. There is no basis for a pretrial dismissal of the indictment in this case. Howard does not identify one and none exist. His motion should be denied. I'm going to pause. Chad has done nothing for over a decade but articulate and lay out several reasons as to why he should, and then when he acquired it, should continue to have, and when Pennsylvania tried to take it away, continue to maintain custody of Alex, which is the premise of the FBI's case. To say that he has not even tried to identify a basis for the dismissal of his indictment is a slap in the face. Guys, just say that you don't have shit on him and call it a day. Because this is what you're saying in so many fucking words. Now, he mentioned Rule 12. I'm going to quote from it again. It authorizes the dismissal of an indictment if its allegations do not suffice to charge an offense, but such dismissals may not be predicated upon the insufficiency of the evidence to prove the indictment's charges. Thus, it is well settled that a pretrial motion to dismiss an indictment is not a permissible vehicle for addressing the sufficiency of government's evidence. Now, I'm going to just quote one particular part. Rule 12 authorizes the dismissal of an indictment if its allegations do not suffice to charge an offense. I know I read the indictment in part 1, but let's read it again. The grand jury charges from in and around November 2006 to in and around May of 2009 in the Western District of Pennsylvania and elsewhere, the defendant, Chad Zachary Hauer, did with the intent to obstruct the lawful exercise of parental rights, remove a child from the United States and retain a child outside of the United States. To wit, the defendant, Chad Zachary Hauer, removed, and then it states Alex's name, date of birth, June 5th, 1996, from the United States, and continues to retain the child outside of the United States. Now, I know it says that dismissals may not be predicated upon the insufficiency of the evidence to prove the indictment's charges, but what if the indictment in and of itself is complete and total fucking bullshit? Does Rule 12 then authorize the dismissal of a fucking indictment? Let's go back to August 30th, 2006. Again, to the order issued by the Pennsylvania judge who took emergency jurisdiction over Alex on this day. Quote, order of the court, and now this 30th day of August, reminding you that the Pennsylvania brief from September stated this happened in a different day, as did the rebuttal to the appeal, but whatever. It actually happened on the 30th day of August 2006 that the court is assuming exclusive jurisdiction of the case. It is hereby ordered that an evidentiary hearing is to be held on Monday, November 6th. I'm just going to skip where it talks about where the courtroom is and who needs to appear. Everybody needs to appear. Alex, I covered that in the previous parts. But Quote, it is also ordered that the Tennessee court's order of October 11th, 2005 be given full faith and credit. Pursuant to that order, the petitioner is to give custody of the child and transport the child to the respondent, Chad Zachary Howard, on August 31st, 2006 by 4:30 p.m. The indictment cites Title 18 United States Code Section 1204. I'm going to quote from that bad boy right now. Quote, Section 1204 makes it a federal crime for a parent or other individual to remove or attempt to remove a child from the United States or retain a child outside of the United States with intent to obstruct another person's custodial rights. Now, as I wrap up part 3, I want you to ask yourself, is this indictment accurate? Did Chad Zachary Howard remove his son Alex from the United States, or did a judge that took emergency jurisdiction over his custodial agreement order Nancy, in spite of this, to put Alex on a plane by August 31st, 2006? Because that's what I believe. So if all of this was just a big mistake on Pennsylvania that eventually just gave up the case, even though they tried to say that they still held Chad in contempt, why won't the FBI let go? Here's Chad's opinion.
How can I resolve this? And the prosecutor said the only way I can resolve this, because he will not try and extradite me again from here, because they've tried to extradite 3 times, they've wasted millions of dollars, and he won't try from here again. He's either going to wait for me to travel, or he's told me, and this is all in transcripts, that I have to turn myself into the U.S. Embassy here in St. Kitts. The problem is there is no U.S. Embassy here in St. Kitts, and he knew that when he said that, but he was saying it just to shut the judge up and get out of court. And even my lawyer pointed that out. The judge was like, well, then I guess he can die there.
Chad divulged to me the issues that would happen if they did dismiss the case, particularly regarding the investigation behind it.
Once they dismiss this case, a couple things are going to happen. One, I can sue the Department of Justice, and I can also seek prosecutorial misconduct charges against the prosecutor. And then the second thing that's going to happen on top of this is every case this FBI agent has touched is going to need to be reviewed again. He planted evidence. He forged evidence. He participated in the forging of evidence.
Time and time again, Nancy was the parent who did everything in her power to obstruct Chad from his inherent right to visitation with his son as Alex's father. Nancy moved Alex from Tennessee to Pennsylvania, failing to inform Knox County, failing to inform Chad. Imagine the panic that Chad felt not knowing where his son was and if he was okay. Then, when Chad was granted temporary custody, Alex had to be removed by Venango County Sheriff's Department because Nancy again would not comply. Again, in 2006, she refused to return Alex to his father after her summer visitation. When Nancy came to St. Kitts on the FBI's dime in 2007, she didn't even bother to see her son. She just dragged him around from lawyer to lawyer, trying to solidify her case, even though she was granted the ability to see him from 9 to 5. And after that, she barely attempted contact or to have a relationship with her son. And imagine how that made Alex feel. He's watching his family go through all of this. He's going through all of this over something that nobody did wrong except for his mother. And his mother, who is justifying all of this, stating that she's a champion for him. Oh, I need to take custody, being abused. And it's all for naught. It's all just to spite Chad, because if she really wanted custody of Alex, she would be going above and beyond to have a relationship with him in those few moments that she had. To me, this is a story of a scorned woman who used her son, her only child, as a pawn to hurt her ex-husband, and a man who did everything he could to shield his son from a mother that did nothing except bring heartbreak to her child's life, and he just wanted to keep him safe. Today, Alex still lives in St. Kitts with his family. He did just get his own place down the street. As for Nick Mick, they refused to take Alex off of the website until last summer, when Chad went viral on TikTok, exposing that Alex was not missing and tagging Nick Mick, who has now blocked him. The problem now is that he's still wanted by the FBI, and Chad is sick. His health is getting worse every day. In fact, the reason why Chad began to use TikTok was mainly because all he can do is record videos. But thankfully, TikTok has helped him out profoundly in getting his story out. I mean, that's how I found him. And I'm just grateful that he at least has that platform.
The reason being is typing is very painful for me. My hands shake and repeated finger movements irritate my muscles. I have severe muscle spasms and severe muscle pain. So typing, I've not been able to even sit up at my main computer since COVID started. It's been about a year and a half since I couldn't talk. There were several years where my face would lock up and I could barely talk.
So we have an assistant U.S. attorney unwilling to drop the case. I asked Chad what needed to happen to get some resolve. And this is what he said. And it's something that his son also said as well.
Well, in the thousands of cases of prosecutorial misconduct that I've researched, the prosecutors do all this stuff out of the darkness. And the only thing that ever gets these types of cases solved is publicity. Once you get publicity and you expose what they're doing, the district attorneys and prosecutors and FBI drop the cases very quickly once they're exposed. But until they're exposed, they will continue to lie and do everything they can behind the scenes, and it'll never get solved. This is the only way out, and that's the way the American system works.
We're just trying to get more media coverage, to get it more public, because that's one thing the FBI absolutely hates. And that's why they haven't dropped the case yet. They don't want to admit that they're wrong. If they're making it public, hopefully they'll admit their mistake and drop all of it.
So this is your call to action as a listener. I say this every time. If you listen to my fucking podcast, I'm going to say this again. Please do something with it. Share someone's story. Share an unsolved case to a friend. In this case, follow Chad. Do whatever you need to do. Repost one of his TikToks. Retweet his tweets. If you're going to listen to parts 1 through 3, guys, you have to engage. Unless you think it's all bullshit, in which case, comment at me and at Chad. It takes 2 seconds to sit there, retweet a tweet. Go look at his TikTok. He has hundreds of videos. Like it. Comment on it. Repost it. Do whatever you have to do. But these people need your help.
And the urgency here. I mean, my life's on the line. I've been passed out to the hospital numerous times here. And they can't do anything for me. So, I mean, if people ask how long can I live? Could be 6 days, 6 weeks, 6 months, 6 years, but I'm in massive pain. I mean, I only left the house like 5 times last year. This week, I barely left the bedroom. I'm just happy to be sitting up in a chair.
I'm including all of Chad's socials in the show notes, as well as his website regarding his son, which is alexisnotmissing.com. And I implore you to please take a look at the evidence. Take a look at what I've presented across 3 episodes and ask yourself if it is okay and if it's warranted that that man has been wanted for federal kidnapping charges for over 15 years. His son lives right down the street. He has other kids, a wife. His health is failing. He wants to stay alive so he can continue to be there for Alex, for his wife, for his other children. And he really, sincerely, and truly needs your help. Before I get emotional because it's happening. If you liked what you heard today, please like, review, subscribe. Guys, if you subscribe, you like, and you leave a review, especially on Apple, it helps me so much. The more you do this, the more help I get, the more visibility I get, the more content I can produce. So if you want me to produce more content, just take a second. You could literally leave a comment that says penis, 5 stars. I don't give a shit. It helps. So just consider doing that. I have a website. I said this before, f.pod.com. I'm actually working on it a lot more now. I have a lot of information on Chad on there right now. I'm working on putting a lot of information there regarding Courtney Heater. I still talk to Debbie. Debbie, I love you all the time. I actually just help her submit a few FOIA requests, but I'm working on putting Courtney's information on there, Brandon Embry's information out there. I still talk to Sarah, so I'm going to be putting a lot of case information on there. And there's a merch store. Check it out. You can find me everywhere at @FThatPod except for Instagram because there is an inactive account that uses @FThatPod and Instagram will not take it down. So on Instagram, I'm @FThat_pod. Love you, bye.